Hello, everybody. This is Brian Norris, and I'm the Associate Director of the OPIS Retail Division. I wanted to start by thanking you all for attending our Petroleum and C-Store M&A Fundamentals course in New Orleans last month. I hope you walked away with a lot of actionable knowledge that can be applied towards any future mergers and acquisitions endeavors you may undertake. It was a pleasure to meet all of you, and based on the surveys we received, I feel confident that most of you found great value in attending the conference. I'd also like to thank you all for your patience and understanding regarding the legal portion of the agenda needing to be rescheduled. As promised, we have found a way to deliver you the content from the instructor and hope that you take away as much value from this recorded presentation as you did from the on-site instruction. I'd also like to thank Jeff for being so accommodating and helping us bring you this content after the fact. At this point, I'd like to introduce you to Jeffrey Leiter, who will be your instructor for this session. Jeffrey Leiter is a shareholder in the Washington, D.C. law firm of Bassman, Mitchell, Alfano, and Leiter. Jeff's practice largely is evenly divided between representing petroleum marketers and trade associations and other nonprofits. Jeff has assisted downstream participants in the petroleum industry, ranging from very large convenience store chains to single-station dealers with a wide array of legal services. He has been counsel to the Independent Lubricant Manufacturers Association since 1981, and in addition to ILMA, Jeff represents more than a dozen other trade associations and nonprofit clients on a wide array of legal, antitrust, and public policy issues. For 22 years, Jeff represented NACS and Sigma on fuels and environmental issues. Jeff is widely recognized as an expert on environmental, health, and safety matters, especially those affecting petroleum marketers and lubricant manufacturers. Jeff writes and lectures extensively on these topics in addition to his client work, which includes compliance counseling, contracts, transactions, enforcement actions, and litigation. Jeff received his Juris Doctor degree from the Catholic University of America's Columbus School of Law, and he received his undergraduate degree from the George Washington University. Jeff and his family reside in Great Falls, Virginia. Jeff will be instructing us on how to manage the legal jigsaw puzzles surrounding mergers and acquisitions. He'll be providing his contact information at the end of the presentation, so please feel free to reach out to him with any questions. Thanks again, Jeff, and at this point, I'll turn control over to you, and we'll go ahead and get started.
Thank you, Brian, and again, folks, I want to apologize for my inability to make it down to New Orleans last month. It certainly is not my style, and I appreciate your understanding. As Brian mentioned, the very last slide does contain has both my phone number and my email address. One of the best parts of participating in conferences such as this is the ability to interact with the attendees, ask questions, answer them, get different perspectives. So I certainly am available to any of you if you want to follow up on anything from my presentation today. I apologize for 1 second here, and I'm trying to manage the slides.
Hey, Jeff, you can just go ahead and click, and it should take you to the next one.
Okay, I apologize.
No worries.
I'm clicking and nothing is happening. There we go.
There you go.
Okay. Sorry for the technical difficulties, folks, but one of the things, being a little bit long in the tooth and having represented petroleum marketers now for almost 37 years, as many of my clients have become good personal friends. I've learned a lot from folks in the petroleum marketing business over this period of time. And through many of those conversations, many of them sidebars at trade association conventions, have been, in many respects, my role as counsel to many of the firms and individuals during the M&A transactions, purchases and sale, really is to act more like shrink, providing, counsel as opposed to legal advice. So in many instances, folks interested in either the buy or the sell side of petroleum marketing facilities, including convenience stores, conversations have been very useful in terms of helping me provide advice to folks. And I guess if I start out is that if you're on the sell side, is not to rush to sell. Think it through. Many instances from the side of someone looking to require is pressure. You know, we've got to move this quickly if we're going to make the deal happen. You know, I tend to suggest that you look at this more like a marriage proposal. It's a reasonable offer. You got a reasonable time to accept. Certainly, if someone approaches you about a possible acquisition, there's a lot of questions that need to be asked, and then I suggest they're open-ended questions in terms of things like, you know, what are your plans? What you want to do about employees? And we'll get to some of that later on during the presentation. But at the same time, it's important to keep your guard up. I mean, folks want to know information about volumes and in-store sales. So it's important to make sure that, and again, we'll discuss this a little later about the use of non-disclosure and confidentiality agreements. Do a little due diligence, and I call it the initial blood test, asking around about the other party. Are they reputable? What kind of you know, company do they have? And then lastly, you know, is it something you can do yourself? You know, looking to take shortcuts, not necessarily always the best way to look at this. That there are personal obligations that might attach with the sale, such as a non-compete. You know, what kind of liabilities are you transferring over to the purchaser, and what might you keep, and how are some of those risks transferred by way of insurance or other mechanisms? So in many respects, you know, one of the things that I learned early on representing folks in the business is that most of them family businesses, some generational changes going on. There are other issues with families and such. So it takes some time to sit back and just, you know, think things through. Some of the things to think through is, you know, what tax implications. Again, the other side has different interests. You know, jumping ahead in the presentation a little bit, one of the areas that I've seen a lot of disputes arise is with respect to reporting tax allocations to the IRS in terms of what value the buyer wants to attach to certain assets for ongoing depreciation or other tax purposes, and what you want to do to, as a seller, to minimize the taxes that might have to be paid to Uncle Sam. One issue that comes up frequently at the very beginning is it a stock sale or an asset sale purchase? And then also to think past closing on the transaction. Is there going to be a non-compete? You know, to the extent that this is a family business that is being sold, you know, can you let go? Are you going to be happy 6 months after the closing, playing golf every day or sailing or doing something you enjoy? Or all of a sudden, are you going to be having regrets that you made the decision to sell because, gee, you're just not happy with where you are, even though you might have a substantial amount of cash in your bank account. So again, before getting into the mechanics of the deal, it's sitting through, talking to family members, looking to folks that you trust, coming to long-term advisors like myself and others, and saying, you know, does this make sense? Is it the right time? Are we making best decision for ourselves? You know, again, thinking on that last piece about just letting go. It's difficult for a lot of folks, and you know, oftentimes egos get in the way on both sides of the transaction. So I tend to ask my clients who are looking at possible transactions a lot of questions. Many of them I've just talked about, but trying to get into the weeds with my client about, does this make sense? Where do you want to go? What's the family want? Is there some tax mechanism you need based on the way the real estate is held and things like that? So there are a lot of questions there that I think need to be asked, and that's why I suggest that oftentimes it's good to almost have a conversation like you're in a therapist's office. and go through that exercise. Certainly, I try to take my clients through and just ask a lot of these questions, oftentimes hard ones, about which direction they want to go. But assuming that you're looking to sell, and oftentimes on the acquisition side, a lot of this is parallel and implies the same. If I'm the marketer, what team do I need to assemble to help me certainly maximize the value for my business and my properties and my C-stores? What's the right way to go about putting this together? Oftentimes, someone, a petroleum marketer, will look to an investment advisor. There are a number of prominent firms in the industry right now that specialize in convenience store properties. They typically will act as the primary advisor for managing the various moving pieces of the transaction. Many times they'll put together an offering memorandum that will include a description of the business, have pro forma financial statements, suggest other issues and aspects of the transaction that would be attractive to a buyer. They certainly, based on their experience with other deals, are able to give a objective perspective on value, based on the condition of the properties, location, sales, local competition, things like that. They can give a much more realistic idea as to what you think is a proper value for the company. They help with putting together advice on tax and accounting structures, particularly on the tax side. When they're representing buyers, they also help go into the market and help raise capital to close the transaction in terms of finding investors, whether it's going to insurance companies, banks, other lenders. And many times the investment advisor will actually go out to a handful of potential buyers and effectively conduct a private auction to try to maximize the value. Over the last 3 years, I've been involved with 3 transactions that have gone through the private auction, and I would say that probably based on initial targets, the final offer price came in about 20% higher in all 3 instances. Next part of the team is the accounting firm. You do need to get proper tax and accounting advice for the treatment of transaction. Many times, more mid-size convenience store companies might have an internal or in-house CFO that can play that role. But I typically want to go to a tax advisor who specializes in helping with transactions, looking at putting value on certain assets. Again, there are issues with the IRS, and to minimize the taxes that would have to be paid, putting appropriate value on these assets. Many times the accountings also provide comfort letters that are needed for lenders and others around certain accounting issues. The other leg of the stool in this transaction would be the legal counsel. Pretty obvious that they would draft and negotiate the transaction documents, and there are a number of them. They also will review issues such as environmental issues, tax, employment governance, real estate, if there are any federal, state, or local rules given the dollar size of the transaction, it could trigger reporting requirements to the Federal Trade Commission under the Hart-Scott-Rodino Act. Market withdrawals. Some states, for example, have, if you're a distributor, providing a right of first refusal to dealers. We've got PMPA, Petroleum Marketing Practices Act considerations to look at that as well. On both sides of the transaction, the lawyers would direct the due diligence. While environmental is certainly important there with the underground storage tanks at most petroleum marketing facilities, there's other due diligence with respect to financial information, third-party obligations, whether there's UCC1s filed, a range of things that need to be listed. There's also fiduciary duties in terms of, to the extent, let's say you've got a convenience store firm that's set up as an LLC with several members, what kind of fiduciary or partners, what kind of fiduciary obligations are there? Is this one partner kind of freelancing, going out, trying to sell the business out from underneath the others? So there's issues there. Typically, the law firms will also render opinions that are needed, particularly on the real estate side, at the closing side. So we've got the investment advisor, the accountants, and the lawyers. They would be the core of the team that would work with you both on both sides of the transaction in terms of getting into the various aspects of getting from start to finish. There are 4 steps that I routinely talk about with my clients in terms of the transaction. The first is it's often important to put together a letter of intent or term sheet. We'll discuss these in a second, but effectively, let's set out the overall framework for the transaction. Secondly is addressing regulatory or other matters. Again, is there some sort of condition precedence in state law, the Petroleum Marketing Practices Act for refiner branded facilities that need to be addressed. Third would be the actual creation of the purchase and sale or merger agreements and the other documents associated with it, the due diligence, basically getting all of the paperwork together. And then lastly, closing, and as part of closing, taking care of the post-closing matters as far as reporting to the IRS, re-registering the underground storage tanks with the state, and things like that. Timing. Let's discuss that for a second. My rule of thumb is that, and oftentimes I'll ask it by clients, how long is it going to take us to get from start to finish on this? Typically, petroleum marketers, and it's not meant as a slight, think that things should happen much quicker than they might otherwise. 2 months, in my mind, is very optimistic. It's going to be hard, particularly with more locations involved, to get closed in that amount of time with the due diligence and the other things that need to be done. I tell my clients, figure on 6 months. Stuff just happens. There's always something that pops up in every transaction I've worked on that was not anticipated or necessarily foreseen by the members of the team and the parties involved in the transaction early on. So I would err on the side of going long rather than short in terms of getting this thing done. I will tell you, I've had one or 2 location deals that have flown through quickly. A couple of them have been IRS 1031 exchanges. Others, even down at I had a sale of one property in western North Carolina a couple of years back that took almost 6 months just to get one property done. So it's going to vary, but my basic point here is err on the long side. So let's go through the 4 steps and run through each of these. And again, if you have specific questions, I certainly invite you to call or email me about them. The letter of intent. What I show here on this particular slide are the various elements that go into the letter of intent. They all have to be there? No, not necessarily, but it's best to try to address as many of these as possible in the letter of intent, particularly the purchase price and other consideration, the payment terms. Is there going to be some sort of holdback by the seller in terms of seller perhaps helping to finance the transaction? Is there going to be some sort of escrow or other issues with respect to environmental? Importantly, whether this is an asset or stock deal. Issues with respect to non-competes, certainly whether the expectation is that the sellers are not going to go out and try to open a new business and compete for a period of time. Importantly, in a lot of the letter of intents is say, all right, we're going to set this letter of intent in place, and while we're negotiating the actual purchase and sale or other merger agreement, you're not going to shop the business to somebody else. So it basically puts in place a hold on the ability to look at other parties. It's important to include in the letter of intent that it's non-binding. And I'll get to a little more detail of this in a second. And oftentimes, folks look up and say, do I really need to have a letter of intent? Can we just move to the purchase and sale agreement? I will tell you that I've had some deals where we've skipped the letter of intent. But I typically encourage my clients to do it. One is it shows the seriousness of the parties. Again, it's trying to create a meeting of the minds with respect to the key elements of transactions, making sure that, particularly for a lot of folks, they understand from the seller's perspective what this means. I mentioned about inserting language that it's not a legally binding document, that the letter of intent itself is not a contract that can be enforced if for some reason after the letter of intent is signed but before the purchase and sale agreement or merger document is executed, that there's a change of mind on the parties. But notwithstanding that legal effect of the letter of intent, most parties have viewed the letter of intent as sacred. I will tell you, just as a side note, while not the overwhelming precedent, some courts have held non-binding letters based on the terms of the letter of intent. So if someone has a change of heart or whatever, the buyer could look up and say, well, you promised to negotiate with me, and the courts have said in many instances that you have to at least try to see if you can come to a meeting of the mind. One issue that comes up oftentimes in the transactions, I know for a fact when you're dealing with some of the investment advisors, they will insist that there be a deposit, a good faith deposit, or in most instances all set up in escrow with a third party to hold the deposit. But the issue becomes, is that deposit or escrow non-refundable or refundable if for some reason between letter of intent and the actual creation of the document, and for that matter closing excuse me, on the transaction, whether the money can come back to the buyer. Again, most instances there's some provision for the initial deposit to be refundable. If the seller is in just a really great position, then perhaps the deposit could be non-refundable. Clearly, I try to write into most of my purchase and sale agreements, some provision where the seller gets to keep the deposit based on certain defaults by the buyer. Oftentimes, particularly with larger transactions, there'll be a specific agreement as to a breakup fee if for some reason the parties can't get to the closing table. Once the letter of intent has been signed by the parties, the next step is to look at the regulatory matters and or some other conditions precedent to moving into the negotiation, finalizing the transactional documents. The regulatory matters typically fall into three baskets. I call them affirmative, negative, or informational. On the affirmative side, those are approval by regulatory agencies, whether it be federal, state, or local, on permits or licenses that can be transferred or assigned. One of the things that has come up in many transactions is a C-store property might have a cell phone tower where the owners rented space on the property to Sprint or Verizon or someone to have their cell phone tower. And there's various licenses associated with that that have to be transferred. Beer and wine licenses in terms of actually having the purchaser go down and be fingerprinted by the state alcohol control board before the permits can be transferred. So those are the kinds of things where the parties to the transactions, particularly the lawyers, need to go through and determine what is it. If there's food preparation operations, what does the local health department require? Certainly post-transaction issues as well can come up here in terms of approval. But we need to list all of these various kinds of approvals that might be necessary. On the negative side, the two that I typically look at and we'll include some discussion of in the purchase and sale agreements are the Hart-Scott-Rodino Act, which is basically transactions over a certain dollar figure, which adjusts every year with the Federal Trade Commission for petroleum marketing, has to be reported. The concern here is whether there's some concentration based on the buyer and seller in the same market that would affect competition rather than competitors. The other is the Foreign Investment National Security Act. There are provisions in that law that restrict who can be a purchaser in the United States. So one concern is getting clear as to making sure that the money to finance this is not coming from Iran, for example. So as a result of that, we have to go through and make sure that those get addressed, that they're actually in the purchase and sale agreements, representations and warranties with respect to these negative determinations. Lastly, the informational. Best example here is transferring and notifying the state of the new ownership of the underground storage tank systems at the particular stores. With respect to the informational, again, typically those would be post-closing. Some of the others, the affirmative and negative, would be after the definitive agreement is signed by the parties, but prior to closing. Again, we need to discuss in the actual transaction documents what happens if there's a failure to obtain the approvals. Is there some cure opportunity? Does the buyer have the opportunity to walk away? What kind of steps need to be taken by the seller, for example, on some of these? Are they commercially reasonable? Are there other kinds of steps? Is it best efforts by the part of the seller or the parties to get these approvals taken care of? So those terms all have various and indefinite meanings and are the types of things, again, that the parties need to look at and negotiate when it gets to a definitive agreement. Slide's not advancing. Excuse me 1 second, folks. other issues that we need to discuss as well under the regulatory matters, and one is supply agreements. Oftentimes, particularly at the distributor level, the supplier has included in the wholesale marketer agreement, whatever you want to call the supply agreement, either a right of first refusal or a right of first offer, where if the distributor is looking to sell the business or even a portion of the business, that the supplier has some opportunity to get a first crack at it. Oftentimes, one of the initial discussions before even the letter of intent is signed is trying to get a waiver of that provision from the supplier and going to ask them, listen, we're contemplating this, will you give us a waiver and get rid of it? Another issue common with particular branded refiners, especially where they have withdrawn from the retail ownership of properties, is they're putting deed restrictions on those locations, particularly with respect to brand, saying that for some defined period of time, that those locations only can sell that particular refiner's brand of product. And similarly, others where they've exited the market have use restrictions. Let's say a property, the purchaser wants to come in and decides in part that they want to, best example, let's say there's a 30-store deal, but maybe 2 or 3 of those stores have strong competition, and perhaps that location might be better where they lease the property or end up reselling the property to a bank. And the supplier on that first sale to the now seller may look up and say that you can't remove the underground storage tanks or do certain efforts to renovate the location without triggering some obligation with the supplier, whether it be their prior consent, let's say, to replacing the tanks, to their saying no to whatever the particular future use of that property may be. I will tell you that we've had mixed success in going to various refiners and getting them to remove deed restrictions. An initial argument in many instances has been that we'll say that the deed restriction is personal to the buyer and ends when they resell. Oftentimes, the courts have agreed with the refiner or supplier that these restrictions run with the land, and then it becomes a negotiating item with both the buyer as well as with the supplier in terms of what happens to those deed restrictions. So it's important to understand just what the supply agreements say, and if in fact there's some of these conditions that may affect the deal. I've seen arguments, and I think they have merit, that in many instances these deed restrictions affect the value of the property. To the extent that the location sells refiner branded fuel, there's a range of Petroleum Marketing Practices Act or PMPA issues that need to be addressed. To the extent that the seller is doing a full market withdrawal, doesn't mean whether they have to give a right of first refusal to the current dealers at those locations. Keep in mind that consignees or consignment agents at these locations are not covered by PMPA. There are, however, various state jobber laws on transfers of interest that need to be looked at. And a handful of states like Maryland have state divorcement laws and restrictions on who can operate the locations. I mentioned the commission dealer with respect to PMPA. It's been a common practice by a number of distributors who have purchased and grown their businesses substantially by acquiring blocks of branded stations from BP and Exxon and Shell and others to convert these locations to commission operation. There are various state laws that affect commission operations as opposed to dealer. Similarly, one of the issues that had been going on for a long time was with respect to whether these commission agents actually are employees of the distributors, from the standpoint that how much control would be exerted over their ability to run the location. The typical setup today with a C-store operation is that the buyer takes the property, controls the gasoline sales, and then leases the location to the commission agent who collects the money for the gasoline sales, but then basically takes the inside sales and on that piece of the deal. Again, it's one of these things that just need to be walked through to make sure that there's no issues on the front end. So assuming we've addressed those, we've got the issues listed, we've looked at the PMPA issues, the supply agreements, then the third step is moving to the definitive agreement between the parties. Keep in mind that the central purpose of the definitive agreement is that it's going to be, once executed by the parties, result in a commitment of substantial resources, including by the buyer for due diligence. An issue, jumping back to the investment advisor and certainly with the lawyer, is putting together, I'll call it the war room, and typically today these are done electronically, but pulling the files, getting all of the financial information, contracts with third parties, the permits, and that having these things all placed in an electronic data room for the due diligence. Again, once the definitive agreement is signed, it becomes a contract that obligates the parties to complete the transaction subject to whatever conditions might be put in the document with respect to walking away. Think about other issues that need to be addressed in the definitive agreement. You know, are there promissory notes that have been given to suppliers, let's say, for image upgrades? Are there promissory notes that have been given to the seller by dealers with respect to monies that might have been advanced to that particular location? Security agreements, loans with the banks, things like that. Bills of sale with respect to hard assets such as pumps, canopies, and other items. Is there going to be a non-compete? What about employees? Are they going to go with the transaction? How are those matters going to be handled? And many times, let's say at the distributor level, there's sales personnel and they have vehicles, and what happens to those leased vehicles? What kinds of resolutions are needed, opinion and comfort letters from the accountants and the lawyers? To the extent that monies are going to be held in escrow, how do those escrow agreements, how the instructions going to be taken? Typically, let's say an escrow agent holding the deposit is going to release the money upon joint instruction from the parties, but are there some instances where instruction from one party is sufficient? And there's no one form of definitive agreement, whether it be purchase and sale or merger agreement. Really the tone of the document, the actual provisions of the document are going to depend largely on the relative negotiating leverage of the parties. To the extent that the buyer holds the upper ground, they may look to get certain elements in there, particularly on the non-compete, let's say, where it might be more restrictive than the seller may otherwise like, but the cash is good. So one of the issues I like to do, particularly when I'm representing the seller, is to go ahead and have a draft agreement in place as part of the bid process with the investment advisors so folks can mark it up. Certainly some of you may have been familiar with a number of the transactions where the refiners were selling blocks of agreements, and the more you marked up the agreement, the less they liked your bid, and particularly when it got to environmental. So again, a lot depends on the relative bargaining position of the parties when work begins on the definitive agreement. You know, getting down into the weeds of the agreement, there certainly are the execution provisions. You know, what's the consideration of things that normally go into this? Is it going to be all cash? Is there some, if it's on a stock deal, is there some deferral, including of compensation, including collars and price protection mechanisms? I had a client last year that sold a significant number of unbranded and branded contracts for open dealers. There's some deferred payout based on volumes, and given what margins were then and what margins are now, you know, some incentive for the sellers at that point to encourage their former customers to continue to do business with these companies. When the contracts, let's say there was a year remaining on an open dealer contract, you know, efforts to ensure that party renewed the agreement at the end of the year. Again, discussion of holdbacks, the earnouts like I just discussed, escrows and things like this is you know, is how much of this is dependent on future performance under the buyer's control. With the buyer coming in with great plans, but all of a sudden they have to maneuver in a different direction for some reason. So these are the kinds of things where it gets worked into the agreement in terms of, okay, there's some earnout or that might be based on performance, but there needs to be some minimum level or some specified level of conduct by the buyer, or else the money gets paid. So again, those are the things that get worked in, partially based on leverage and bargaining position of the parties. Importantly, what kind of purchase price adjustments can be made between the initial draft of the agreement, the letter of intent, and the actual signing of the definitive agreement, and then closing. To the extent, let's say, the due diligence suggests that there might be a problem with one or two locations, how they get deleted from the deal, and what kind of adjustments to the purchase price gets made. To the extent, let's say it's a distributor and they're continuing to go out and hustle business, how do you value new contracts that might be added during that period of time? So those are the kinds of things that need to be addressed in the agreement. Other things that are normal would be a provision that just says that the seller is going to operate the business in the normal course between signing and closing. I'll usually put a PS in there about the ability to either borrow money or get into other obligations. Let's say a contract is coming up during that period between signing and closing with respect to a revolving credit line with the bank. You know, look at something like that. What happens in that with respect to ongoing obligations or things that come up in the normal course? And some mechanism for resolving disputes if there's some disagreement between buyer and seller with respect to what's in the normal course of business during that period of time. For years, folks have normally glossed over the reps and warranties section of the agreements. They're saying, you know, that this is just boilerplate that lawyers put in here. But more often than not today, I find, and I stress to my clients, the importance of the representations and warranties. The typical seller's reps and warranties are their ability to sell, that they've obtained all of the necessary consents, such as from suppliers, lenders. They might have a third party that owns a C-store property and they need that landlord's consent to the closing. And regulatory consents I've talked about in terms of the affirmative ones early on, as well as the condition of the business and the assets. I'll get into knowledge qualifiers in a few minutes, but with respect that the business is what they say it is. The reps and warranties, again, must be true and accurate, both at signing and closing. So normally, the definitive agreement will include a provision that provides for a bring down of those reps and warranties at closing. Typically, a breach of the reps and warranties will trigger a claim under an indemnification provision in the agreement. And again, the reps and warranties support the due diligence process and any adjustments that are needed there. So, contrary to how a lot of folks feel, that I find that the reps and warranties are critical and spend a lot of time on them and the drafting of the agreements, as well as discussing them with the seller, if the seller is my client, or on the buyer's side, in terms of what kind of expectations we have with respect to those representations and warranties. Other kinds of reps and warranties: accuracy of the financial statements, the validity of key contracts, condition of certain assets, whether there are any existing environmental claims, or any litigation going on with respect to environmental. Is there any enforcement issues going on? Aware of any problems with overall compliance, environmental compliance for the locations. Sufficiency of the assets, and I say here particularly intellectual property, particularly if you got a private branded location that's operating under a certain name, Jeff's Gas or Jeff's Grab and Go, that if those intellectual property is being assigned, that there's no impediments to it, that they've been properly registered, let's say with the Patent and Trademark Office in D.C. or under state law. Is the name too close to somebody else? There's there are a number of convenience store chains that might have the word TRAC, T-R-A-C or T-R-A-C-K in their name. And geographically, do they overlap? Does it present confusion in the marketplace? So these are the kinds of things that should be addressed at the reps and warranties level. Employee matters, including benefits with respect to issues there. Typically, there'll be a rep and warranty with respect to accounts receivable, taxes, but clearly when I'm representing the seller, I'm not going to represent future financial performance. An issue that oftentimes comes up is an accusation that the seller has, let's say, lowered street prices to gin up volumes, and that the volumes are not accurate. So certainly want to include something in here that we're not guaranteeing the financial performance once the properties have been transferred. I mentioned earlier that, and this becomes a big negotiating point. Oftentimes the reps and warranties saying that there's been no material adverse change. That put something in here that says if there were somehow a breach of a particular rep and warranty, that it is either not material or would not rise to the level of creating or negatively or adversely affecting the value of the transaction. So we're looking here at these kinds of qualifiers. Again, it depends on the negotiating leverage of the parties. Typically, it is something that ends up being negotiated by the attorneys, as well as the principals during the a certain amount of discussion takes place in the reps and warranties with respect to knowledge. The knowledge qualifier limits the truth to accuracy of the statement based on particular individual's knowledge. Oftentimes, let's say in a good-sized convenience store chain, the seller doesn't have particular knowledge as to whether the tank at a particular tank number 3 at a particular location is tight or not. So that, to the best of the seller's knowledge, some sort of qualifier is limited. So what I tend to try to do is to go through on either side of the transaction I'm working on and figure out, who is the party that's supposed to have the knowledge. It may be on environmental, but I'm looking for someone other than the principal to provide a rep and warranty with respect to the environmental, or based on the principal's reasonable request to those within the company with knowledge, and based on that inquiry that to the best of their knowledge. So it becomes a limiter, and it's something that, again, gets negotiated out during the process. Moving past the reps and warranties, you then move into the section of the agreement that I call covenants. These typically are agreements that regulate the actions between the sellers and buyers and what they may do between signing and closing. So there are conditions preceding to closing with respect to, let's say, title examination for real estate. Often these covenants then become the basis for indemnification claims that could come up afterwards. There's 3 broad categories of covenants. One are operation. These typically are the handcuffs that regulate the operation of the business. The buyer is looking to buy the assets, the operation of the business, and the form and conditions that it sees on the front end and expects on the back end. Adjustments for CapEx and cash flow management. Again, these will typically get tied to the purchase price adjustments. The covenant to operate in the normal course with limits on the ability to buy or sell assets. And then other restrictions such as making the deal dependent on retaining key employees or offering employment and how employees are going to be handled. The second type of covenant I describe as efforts covenants. These are really agreements by both sides to complete the transaction. Sometimes the efforts provisions become contentious where parties don't trust one another. Typically, best efforts would be the commitment of parties to work together to obtain necessary consents, again, from suppliers, third-party landlords, or where necessary, condition proceedings from government agencies. The third area is financing, setting forth the steps the buyer, if it's going to borrow money to obtain the financing, what's the specific level of commitment necessary for the financing. Again, these are the kinds of things that need to be contained in the covenants. The next area of the agreement is really looking at conditions to closing. What are the steps the various parties are going to undertake between signing the agreement and closing? Again, these portions of the agreement regulate the steps necessary, including, where appropriate, bringing down relevant reps and warranties at closing, as if those made on the front end of the definitive agreement are the same at closing. The consents that are necessary. Again, these are often embedded in other contracts, supply agreements, leases, contracts with vendors with respect to, let's say, the coolers in this convenience store. Other equipment is there. To the extent that you might sublease space within a convenience store for Dunkin' Donuts or some other kind of operation, what consents there. And what happens if you can't get some of these consents? Are they material or non-material, and what happens? So these are the kinds of things that need to be addressed as well as conditions to closing. Financing contingencies, labor and tax-related conditions, again, dealing with employees, and what happens there. What happens if there's some material adverse change between the time of signing the definitive agreement and closing? Margins all of a sudden go down considerably, sales drop. There's fire at a facility. Lawsuit is brought against the seller for some reason. So these things that could materially affect the value of the transaction and how those get worked in as conditions to closing. Certainly there's a discussion in the agreement necessary for how due diligence is going to be conducted, how long it's going to take, and what happens. And I'll discuss due diligence a little bit further in a minute. Critical provision in all the definitive agreements are what kind of indemnifications. Typically, the buyer wants some protection from the seller with respect to both pre-closing and post-closing breaches of reps and warranties, covenants with respect to the transaction, environmental matters, and other things prior to closing. Certainly the seller wants some protection afterwards for breaches by the buyer, particularly with respect to, critically, on environmental matters that could come up or other issues with employees that might arise post-closing. The typical issues that arise with the structure of the indemnification. Is there a survival period? Do reps and warranties expire at closing? Is there some period afterwards for various reps and warranties? Let's say on environmental, is there a 2-year look back or longer period of time? Oftentimes, on various claims like this, they may be subject to state statute of limitation requirements. Is there a material size or a minimum size of any individual claim? Are you looking here at a issue with, there might be a $2,000 issue? Is that something that the buyer has the right to go back to the seller, or does it have to rise to a certain threshold before the indemnification triggers? Oftentimes, we'll put baskets or tiers in indemnification. What I mean by this is, in a cap, we'll look at saying, okay, up to a certain dollar level, it's the buyer's. Then the buyer can come back to the seller, and the seller takes the second layer up to a certain amount. Anything over that cap then goes back to the buyer. So that's one way to look at it. Oftentimes, in order to deal with some of these issues, is there going to be an escrow in place? I hate escrows post-closing, but oftentimes a buyer will insist on a holdback, let's say, for environmental. Other instances is, let's say, where you might have a significant dealer population, and those dealers have promissory notes that they're amortizing on a cents per gallon basis with the distributor. And how good are those dealers? If the dealer defaults and is owing a couple $100,000, should that become the buyer's problem, or do we put it, let's say, a escrow in place for a year or two for some amount, particularly if the buyer is paying value to the seller for those promissory notes? And then, can I tie this to insurance, particularly on the environmental? Is there something here that says we're going to look first to the insurance? Who pays the deductible? And I will tell you that in some instances, we've had sellers purchase both D&O, purchase reps and warranties insurance. It is available in the marketplace. It's not cheap, but in some instances the seller felt that they needed it. Other instances, certainly looking to, again on the environmental, we're going to look to the state tank trust fund to the extent one exists in that particular state for the risk transfer or environmental insurance. And purchasing a tail, let's say, where the buyer can come in for let's say the first year and look to the seller's tank insurance. Certainly we need termination provisions. What are the rights of either side to terminate the agreement prior to closing? And if that occurs, what happens to the deposit? Is there a breakup fee? What happens to the expenses that both sides have incurred in terms of legal accounting? Whether there's a non-refundable fee to the investment advisor. Those all need to be addressed in termination provisions in the agreement. Other things that typically are included in, I'll call the miscellaneous basket. A number of states still have bulk sales laws that need to be addressed in terms of possible creditors having the ability to come in and get notified, particularly on product. Publicity, how do you plan to handle this in terms of press releases, informing employees, other key parties? Are there any non-competition, non-solicitation, or post-closing obligations on the part of the seller? Non-solicitation here means, all right, I'm buying the business from you and I'm taking all these employees with me for a period of time, whether it be a year, 2 years. You can't come in and try to hire away those people, depending on what you're going to do after closing. It also applies, let's say, to the extent that you sell some but not all of the business, going after former accounts and soliciting them to drop and come with you. So those are things that need to be addressed as well. Assignment assumption agreements. These are critical in terms of what's happening to that supply agreement that I have with the refiner. Are we going to assign that to the buyer? Are we going to terminate it? Oftentimes, a supply agreement will have, if you terminate before the normal expiration or purchase volumes have been acquired and been bought, there's a liquidated damages provision. So those all need to be looked at. Another key piece, again, in a larger transaction, is there some sort of transition services agreement? Is the seller going to continue to provide some sort of assistance to the buyer with respect to employees, access to certain information, and that after the closing takes place? Again, these all get worked into that definitive agreement. And then there's all the schedules and exhibits that go with the agreement. Drafts of bills of sale, drafts of the assignment and assumption agreements with respect to contracts, actual other obligations, let's say leases or other contracts, whether it be for leased vehicles or what have you, and making sure that all of those disclosure schedules are properly set forth in the agreement, and the actual schedules, whether they're completed at the signing or whether they're going to be brought down by closing, all get addressed in the agreement. So assuming we get all of that done, we also want to talk about the due diligence aspect of it. And oftentimes folks have, particularly in C-store transactions, have looked at the environmental. But keep in mind there's a full range of issues that need to be looked at by the buyer. And when I'm representing the buyer, I've got a very detailed due diligence checklist that I'm looking at. I'm depending largely on these matters to be set forth in the electronic data room that's created, but then even going beyond it if necessary. But obviously, you're going to be looking at financial matters and how good is the information that has been provided by the seller with respect to volumes and cash flows and other things that go to the financial side. Have their tax returns been filed? Are there any outstanding issues with state revenue departments, let's say with respect to motor fuel excise taxes, or particularly where the point of collection hasn't been moved up to the rack? Technology, intellectual matters. Yeah. Are the computers leased? Where's the software? The brands, particularly with, let's say, you're using private brands, how the intellectual property, are there license agreements in place? Moving on to material contracts, where we've got customers, suppliers, looking at those agreements with respect to consents that might be needed as a condition proceeding to closing. Have there been guarantees made both personally and corporate? Loans with respect to customers or with others? Are there credit issues with respect to any dealers and customers? Has there been litigation or enforcement actions with governmental agencies that resulted in settlement agreements or consent agreements? I like to point out to folks oftentimes that petroleum marketers have been pulled in, rightfully or wrongly, into Superfund cases, and they might have entered into a payment agreement with the government to get out of the case, where they get contribution protection from the government and a covenant not to sue. I want to make sure that those agreements are in place, and I can see them, and those get assigned to me, and all of a sudden, as a buyer, I'm not looking at assuming some sort of Superfund risk or other kind of risk, particularly on the environmental side. Employment agreements, leases for equipment, both related to the petroleum dispensing systems as well as inside the convenience store. Real estate leases, franchise agreements, again, if we're selling Domino's Pizza or Dunkin' Donuts or any kind of operation that might be going on within the C-store. The due diligence also just is to confirm for the buyer, is this a strategic fit? Does it agree with what we want to do in the business? Are we able to step in, and what kind of investments need to be made? So those are the kinds of things that the buyer's looking at. Employee management issues. A big issue through the Obama administration has been the use of independent contractors, the consulting agreements. Are these employees classified correctly? I want to look at the employee handbooks or manuals and see what they say in terms of various kinds of leave issues, maternity leave, how much time off people get, handling of things such as social media use and use of vehicles and that. Is there any actual or threatened litigation that the seller is aware of? Clearly looking at tax matters. Are there any antitrust or other regulatory issues that are in place in terms of anything that would give concern, apart from Hart-Scott-Rodino, about the nature of the transaction? Has there been some sort of agreement put in place? I'll put in this basket the pricing philosophy of the seller in terms of how they are pricing product and whether there's any issues there that might arise. To environmental, to vehicles, the various policies, what kind of limits do they have, what kind of umbrella might be in place. Then I move on to other corporate things, such as good standing. Are the entities properly registered and in good standing with the state in which they're licensed? To the extent, let's say, and I found the kid that most petroleum marketers I know are tri-state. They all seem to operate in three states or more. But are they registered to do business in all those states? And is all of that paperwork in order? Clearly, the environmental with C-store and other petroleum marketing transactions is critical. You know, I want to see, has the seller gone in, conducted any audits, where are the records, reports, to the extent that there have been releases at various locations, looking at that paperwork, trying to get some sense as coming in, am I looking at having to upgrade locations? Am I assuming, that there's stuff underground that might need to be addressed in the future? A critical thing right now is that EPA issued amendments to its longstanding tank rules in July of 2015. They became effective in October of that year. A critical component is that the majority of the states are approved state programs, and they have until October of 2018 to come into EPA with their plans to upgrade and update their regulations to comport with the new federal ones with respect to inspections and testing. Certainly operator training has been something that's been in place for a couple of years now. I want to make sure, what kind of Class A, B, and C operator training, are the records there. Some states do require submission, but looking and see that. Are the permits and licenses in place? While we've been successful at long last getting rid of stage 2 vapor recovery, are those permits in place? Have the necessary tests been done? I want to see any correspondence with either EPA or the state agencies. Has there been any enforcement action, claims, or litigation involving environmental? Any known Superfund exposure? A problem here has come up in many instances where marketers have replaced their underground storage tanks, upgraded the locations, and I'll put it in quote, dirty, end quote, dirt has been moved to a site that may be used for asphalt patching or proper disposal, and something went wrong, and it's now a Superfund site. There is a line of cases known as Wilshire Westwood that protects that dirty dirt, but it usually means you have to buy your way out. Have there been other issues with respect to the site where you had solvents or cleaners or other kinds of disposal things that took place? I'm going to want a rep and warranty with respect to that, but I want to take a look at what has been the management practices with respect to those issues over the number of years. Contractual issues related to environmental liability. Has there been, let's say you've got in-tank gauges, the Veeder-Root TLS 350s, and you're using Veeder-Root or some third-party contract. You've got statistical inventory reconciliation where you're using a third party. What happens on the transfer? Do those contracts go? Insurance versus state funds, and how good is the insurance policy? How good is the state fund that we're dealing with? Particularly for older convenience stores, are there any asbestos issues with respect to either the insulation or the floor tiling themselves? Significant issue is whether I'm looking at any requirement, particularly with lenders. A lender will typically ask for phase 1 investigation to be done. Those are relatively uniform based on an ASTM method. And what would trigger my wanting to go in and either tightness test the tank, poke holes with geoprobes, do some other kind of more detailed investigation about potential environmental risk at a location. So those are addressed in the agreement as well as the due diligence. And if I'm going to do a phase 2, how much time do I have? Certainly it's at my expense, but do I have access to the sites to conduct that further work? If we find a problem, whose obligation is it to notify the regulatory agency, or do I just hand it over to the seller and expect them to take care of it? Oftentimes the seller, where there's leverage, does not want the buyer poking around in the property, and at that point then I'm going to want to make sure that I've got a much stronger indemnification provision with respect to environmental claims. So these are the kinds of things that would get typically addressed both in the in the definitive agreement as well as the actual due diligence when it's conducted. To the extent that I've got concerns with the environmental, am I able to drop that location from the deal? If I end up finding a larger number of environmental problems, whether it reaches a particular dollar threshold, I can walk away from the deal and get my deposit back. So those are the kinds of things that I'm looking at as part of both the agreement and the actual due diligence. Are there any related party transactions as part of the due diligence? To the extent that, it's a family-owned business and, we've set up each property as a separate LLC with different family members, and perhaps there are loans to family members to buy the properties, or there's sale and leaseback type things within the company, that those are the kinds of things that need to be addressed as well through due diligence. And then overall compliance with laws. There's typically a rep and warranty that says the seller, to the best of its knowledge, has materially or substantially or significantly complied with all laws and regulations, and looking to see if, in fact, there are any other issues out there that deal with the various kinds of, particularly at state and local level, with respect to beer and wine licenses, other issues with respect to employees. Go down the list here, but making sure that, in fact, that there's significant compliance, and expecting, if there are any issues, that those have been set forth by the seller in their data room. Clearly, where there's real estate, I want to look at the deeds to the property, the leases, have somebody run the title reports and bring those down. Are there financing leases, sale and leaseback agreements? Again, oftentimes those might have some sort of consent provisions. Any conditional sales agreement, operating leases. I'll add, again, the supply agreements, the various other kinds of deed restrictions I talked about earlier with respect to refiner brands, or making any kind of significant improvements to the property where I might turn some dirt that gives concern to the environmental, to the supplier that sold that location a while back. As I've mentioned a number of times, typically the due diligence now is done through online data rooms. I will spend some time particularly with the investment advisor. Many times the investment advisor will be the one who actually organizes and puts the data room together for the seller. But making sure that there are disclosure schedules with respect to the accuracy of the materials in the data room, that the seller, to the best of its knowledge, has included everything. And then from time to time, data room issues come up with respect to who has access, whether there might be pages missing from a document, whether the materials in there are actually complete or not. So I'll try to address them the best I can. I typically just will put it in a basket with respect to the disclosures that are made by the seller. So we've got the definitive agreement that's been signed. The due diligence has been done. The buyer finds the due diligence satisfactory. Conditioned proceedings with respect to the various approvals that might be necessary, the consents, all of those things are in place. The fourth and final step then is moving to the closing and the actual consummation of the transaction. I know many of you have probably been involved with transactions, and certainly issues that come up oftentimes issues come up at the closing that get addressed. Typically the closing is very detail-oriented. More and more, many of these closings are being done by conference call and online, as opposed to necessarily in person, with a lot of signing of documents going back and forth, being scanned and sent over the wires to the other side. But effectively, the closing is the consummation of the transaction. The purchase price gets paid. Ownership gets transferred. any of the ancillary documents, the assignment and assumption agreements, the non-competes, the various side agreements are executed, the title documents are signed. To the extent security interests need to be released, assigned, or put in place, that those get executed at the closing. Again, typically this is a very detailed process where it basically goes through every step. I normally will put together and work with the other attorney from the other side on a closing checklist, and it basically will follow the outline of the definitive agreement. Do we have the certificate of good standing in place from the various states that show that the reps and warranties made with respect to good standing are accurate? Have we gone down through and obtained the the supplier's consent, let's say, with respect to the assignment of a supply agreement? Do we have the other agreements in place with respect to consents from vendors and others that might be in place, the government agency with respect to transferring beer and wine licenses? Those all would be part of the checklist we would put in place, and basically just walk through every one, sign one by one, make sure the agreements are signed, everything's in place. The last piece that often is addressed in the definitive agreement is, and outside of, let's say, the purchase price where real estate's involved, is how are we going to handle fuel and merchandise inventories? And oftentimes on the day of closing, there's going to be some stick readings done in the tanks. There'll be inventories of merchandise done. Oftentimes the third party's brought in. Other times the parties agree to the methodology with respect to these inventories. And there'll be a post-closing payment, whether it be 3 days, a week, but sometime close to closing, there'll be additional payments by the buyer for the various inventories that are involved in the transfer. Sometimes it involves simply paying for the fuel at whatever the invoice price was. Other times there's some adjustment made based on whatever the market may be 2 or 3 days later. Those all get worked out by the parties in the definitive agreement in terms of how the inventories are going to be calculated and adjustment and how that payment is made. Typically, again, it'll happen within a day or two or a week after the closing on the transaction. Once the closing is done, the money is moved and the keys are handed over to the buyer. There are post-closing activities, and the issue becomes who's responsible for taking care of these various issues. Oftentimes it becomes the buyer's obligation to perfect its security interest by filing or making necessary recordings. Let's say where you've got customers with a UCC1 in place, typically an amendment is done through a UCC3 where the buyer now becomes, then it has the new security interest in whatever, it's the inventory of that dealer or what have you. Certainly there's the post-closing contractual obligations with respect to non-competes and things like that. One issue where I've seen a significant number of problems come up are tax allocation filings. Sometimes in order to get the deal through, the parties agree that they're going to set forth a non-binding allocation of the purchase price. How much is getting assigned to a particular property, to hard assets like pumps and tanks, or fixtures and things like this, to vehicles. And the parties have obligations to file various forms with the IRS within a certain period of time with respect to the actual agreement on what the transaction, how the purchase price is allocated. I've had some instances where the parties have agreed to disagree and file their own forms with the IRS and figure out if they get audited, they'll work it out down the road. Other instances, I prefer to try to have some pre-closing agreement as to the allocation, particularly to force the buyer, if I'm the seller, to agree to the allocation in advance of closing and working out some mechanism prior to closing to resolve any disputes with respect to the allocation. But clearly, the post-closing tax allocation filings is an area that I think folks need to pay more attention to on the front end of the deals. I've just seen it just come up that afterwards the parties have looked up and said, you know, we disagree as to how the purchase price should be allocated. And again, the seller is trying to reduce its tax obligation. The seller's trying to, the buyer's trying to maximize what it can either depreciate or spread out over a longer period of time with respect to its obligations with Uncle Sam. Again, the earn-out payments and making sure that there's the ability to check the records and do the things that are necessary. Living up to the covenants not to compete, non-solicitation, and then, you know, lastly, most states require within 30 days of closing that updated tank notification forms be filled out. Here, the problem that oftentimes comes up is that the tank notifications are supposed to address who is the new owner of the tank. And many times, let's say the buyer either at closing, prior to closing, at closing, or shortly afterwards might assign its interest. So let's say the buyer becomes ABC Investment Company, and prior to closing, it decides to assign the rights for particular locations to separate LLCs and rights set up for each location. And there may be an LLC that owns the real estate and then another one that operates it after closing. And the question becomes, all right, who's the right party with respect to that tank notification to the state? It becomes important for a number of reasons, from enforcement issues that might come down the road, where a lot of these EPA inspectors just don't understand enough about how you operate your businesses, to actual issues that might arise. Got actually a case going on right now where historical releases where the state wasn't as aggressive with respect to dealing with some groundwater contamination, soil contamination. There were no nearby potable wells. So they closed cases a while back, suggesting that, you know, while their contamination was there, that, you know, they felt it wasn't going anywhere. And, you know, the next door neighbor might be a auto repair facility that all of a sudden now is a Walgreens or a Rite Aid or a CVS. And guess what? They're having fumes come into their building. And you start having issues going back and forth. And the important issue becomes, who's the right party with respect to this? If it's ABC Investment Co. and they happen to be in a different state, doesn't mean we're in federal court. So there's those kind of issues where it becomes relevant down the road. But clearly, making sure that both on the seller side and the buyer side, it becomes important to understand what kind of post-closing obligations are there just to finish the transaction, get all the paperwork in to the relevant parties, and then have folks go on with their business and their lives. I mentioned really at the front end when it came to how much time it takes to do the transaction, and said stuff always happens. Well, here's some of the stuff that can happen. Where you have, let's say, a decent-sized operation where it's operated through dealers or consignees, they refuse to cooperate. They're holding out either for a better deal from the buyer. You know, let's say they might be on a DTW or on a Rack Plus deal, all of a sudden they just want a better pricing arrangement, and they're going to hold out until they get it. They might be required to sign some consents, let's say, and refuse to, or they got maybe 2 years left on their deal, and let's say they're an open dealer and you're supplying them at the location, and it's not so much price, but they just want to be able to walk away, and they think the grass is greener on the other side, and you can't get their consent, and what do you need to do? So that's clearly a big issue. I've talked about the PMPA issues in terms of some of the initial activities with respect to they get a right of first refusal. If they want to buy the property and have the right to buy the property, whether under PMPA or state distributor law, what happens? You find out that the reps and warranties were wrong and there's been a breach. A typical one has been the buyer has some sort of remorse down the road and says, well, gee, the financial statements that we got in the offering memorandum from the financial advisor way up front were misleading. The due diligence, the financial statements were put in by the company's CFO, and gee, they omitted material provisions from those financial statements. Typically, again, becomes environmental matters where we're looking to say there's been some sort of breach of the contract by the seller with respect to what they represented to be the environmental condition of these properties. Again, from the time the deal gets announced and the closing, and there's a delay in closing, that there's some change in financial performance. Employees just are worried and things start falling through the cracks. Key employees leave. They decide just, gee, I'm going to go somewhere else because I either don't like the buyer, I'm worried about I might have to move, or what have you, and someone who's really critical to the operation leaves. And oftentimes the problem I have representing sellers is, gee, all of a sudden I made a bad decision. There's some remorse on my part as the seller with respect to the transaction. I'm not getting enough money. Gee, I really wanted to keep this in the family. There's second thoughts about letting go and what's going to happen, particularly if there's a non-compete. And let's say maybe some family members are involved in business and others aren't. And, it's created some distress with respect to family dynamics. So there's a range of things that go into the stuff happens basket, and just point out, it's hard to predict what those can be, but certainly there's going to be some of it that comes up. So with that, that's the conclusion of my presentation. Again, I apologize profusely for not being able to make it to New Orleans. I didn't expect to be in the emergency room until 5 a.m. the day I was supposed to come down there. And so I appreciate your forbearance, and hopefully through this recording and webinar that I've made it up in part to you. Again, I encourage you, if you have any questions at all about my presentation, I'm happy to discuss them. If you just want to chat about anything, I'm happy to do that as well. You see my phone number, my email address here. I am relatively prompt in getting back to folks, and if for some reason I'm not, please pick up the phone, but it means that I'm probably out of the office. But I appreciate your time. Hopefully there's been some elements of my presentation that have been useful to you as you go forward and look at possible purchase and sales and other kinds of transactions in the business. And wish you good luck, and again, appreciate your time. Thank you.
Great. Thank you, Jeff. I did have one question for you. We lost the audio on you for about 5 seconds here or there at one point in time, and it was when you were talking about letter of intent. And you said something about how some courts have held non-binding letters of intent as binding and that there's some sort of precedent there. But we lost you right in the middle of that, so I just wanted to know if you could please clarify that just a little bit for us.
Sure. Brian, what I typically will write in, insist in letter of intent is a discussion, if I'm representing the seller, that the letter of intent is non-binding. The fact that I sign a letter of intent to sell my business to you does not create a contractual obligation for me to close. All I'm agreeing to is that based on these various elements outlined in the letter of intent, that I will move toward a definitive agreement, and if all the conditions of that are met, then we'll close. The issue that's come up with is that sometime after signing of the letter of intent and before the definitive agreement is negotiated or signed, that there's either seller's remorse, there's some issue that comes up, and the seller decides it wants to walk away from the transaction. In some instances, buyers have gone to court and have obtained a declaratory relief from the court that requires the seller to negotiate in good faith. So that's my point, is that while it doesn't necessarily create a binding obligation to contract and close, some courts have looked up and says the letter of intent does require you to at least negotiate in good faith. And at the end, if you've negotiated in good faith and you can't reach a meeting of the minds, then you can walk away. But at least there's an obligation to try to negotiate in good faith.
Great. Thanks. That clears that up for us. Well, that's all we had here. I'd just like to take a chance to thank you, Jeff, once again for being so accommodating and helping us record this after the fact. And of course, everybody understands that you weren't able to make it down to New Orleans. And I think this is a great solution for everyone. I'd also like to thank Britt, Desiree, and Katie in the OPIS Conference and Marketing Department for helping us put this together. And last but certainly not least, thank all the attendees who were able to make it down to New Orleans for helping make this conference such a success. We definitely hope that we will see you all later this year at our next event. Thanks again.